Yes, we waive the formal reading.
Thank you, sir. Ms. Leonard, on indictment number 2020 CR 128 on offense 001, alleging manslaughter, how do you plead? I'm sorry, ma'am, we're trying to pick it up on a recording system. Do you plead guilty or not guilty? Not guilty. Thank you, ma'am. On offense 002, alleging reckless endangerment of a child, how do you plead? Not guilty. Thank you, ma'am.
Okay, is there a question of bail?
There is, Your Honor. Good morning, Jessica Kenny on behalf of the Commonwealth. Can you hear me sufficiently with the mouse on from there?
Yes.
Thank you. Your Honor, the Commonwealth is requesting a $100,000 cash bail in this matter. We're also asking the court to impose a series of conditions that have been imposed in the district court when this defendant had been arraigned only on a misdemeanor charge of reckless endangerment of a child. I have brought a copy of those conditions from the Brockton District Court, if that assists the court.
Call for court officers.
Those conditions include, Your Honor, GPS monitoring, no contact whatsoever with her children, no drugs or alcohol with random screens, complying with mental health evaluations, as well as complying with DCF and probate court orders, and that she not possess a firearm. I want to make it clear, Your Honor, we had moved for dangerousness when this case originally happened out of the Brockton District Court. And again, at that time, the charge is only a misdemeanor. The Commonwealth at that time was very concerned about the safety of Ms. Leonard's other children, given the facts in this case. Since that date, approximately 8 months ago, that concern is not necessarily as prevalent for the Commonwealth, given that the children have all been placed and are on track for adoption now. And given that Ms. Leonard appears to have complied with that order from the district court that she had no contact with her children. So while our concerns necessarily for her dangerousness may not be as strong as they maybe were in December, we still have significant concerns, Your Honor, about her violent criminal history, about her history of defaults, about the very serious allegations and nature of this case, and certainly the fact, Your Honor, that she now is facing felony manslaughter charges, which carry up to 20 years in state prison. Your Honor, we also would consider the defendant before you to be a significant flight risk, and I can certainly outline all of that for the court. Just by way of history, factual background, Your Honor, the defendant before you is the biological mother of 7 children. She had lost custody of all 7 of her children up until the fall of this past year, 2019. And at that time, the Department of Children and Families began to give her back physical custody of her children while the department maintained legal custody. So in about a 2-month period, Ms. Leonard physically got back all 7 of her children. They range in age from the 12-year-old is the oldest to 1-year-old twins are the youngest. The victim in this case was the defendant's 2-year-old daughter, Farrell. She was sent back to her mother's home around Thanksgiving time in 2019. As you'll hear, Your Honor, she ultimately died in December of 2019. The night that she was taken to the hospital, Ms. Leonard called 911, and in about a 3.5-minute call reported that she didn't think her daughter was breathing. When the EMTs arrived, Your Honor, she was propped up, she being Farrell, was propped up on a couch and wrapped in a blanket. They immediately began resuscitation attempts. The child was taken to Brockton Hospital initially, where they observed a subdural hematoma, and they immediately contemplated or considered diagnoses that included non-accidental trauma to the child based on the child's condition that included bruises and cuts of various stages of healing all over her body, including places such as between her shoulder blades where the child couldn't reach herself. The child was airlifted to Children's Hospital. She was brain dead when she arrived there. She was ultimately pronounced dead about a day later at that hospital, Your Honor. The defendant before you initially told police that she had gone to wake her daughter to use the bathroom in the middle of the night when she found her unresponsive. However, a subsequent investigation, interviews with some of the other children, as well as some of the physical evidence, seemed to indicate that that's not exactly what happened, that the child instead was having difficulty breathing that entire night. Some of the other children that were interviewed that were in the home that night demonstrated wheezing sounds that Lyric was making, and that despite her apparent distress and inability to breathe, the propped her up on a couch. The children told investigators that it was only after Lyric stopped breathing that the defendant checked her pulse and announced to the other children that she was dead, and then called 911. As I indicated, that call was only 3.5 minutes long. You can hear the first responders knocking on the door at the end of the call. However, when they walked in the house, the other 6 children were completely dressed in coats, as if they were ready to leave the home. It is also apparent when crime scene services arrived that it does not appear that Lyric Farrell ever was placed in her bed that night. Her bed was covered in just plastic. It had no sheets on it, and it had toys on top of it from Christmas that had not been unwrapped or unpackaged. It didn't appear that there was any place for someone to have gone to bed that night. Ms. Leonard was heard telling people in the emergency room that she had videos of her daughter injuring herself. That is, she claimed she would bang her head on the ground, and she offered that as an explanation for maybe how the child would have a subdural hematoma. The state police did obtain the defendant's cell phone, and they downloaded it, and they located these videos. The videos, Your Honor, occur from the 26th and the 27th. They show 2-year-old Lyric Farrell in just absolutely deplorable conditions. She can't hold her own head up. She can't focus her eyes. She can't stand up. And in all the videos, or most of the videos, Mom is yelling at the 2-year-old, picking her head up, trying to get her to look around, and then the 2-year-old will slump her head right back down. She's naked in most of the videos. She looks very, very thin. She looks like it's very obvious in the videos that the child is in some type of acute distress. So what is new since we arraigned the case in the district court and part of the investigation that ultimately led to the indictment for manslaughter, we have the autopsy report back, Your Honor, at this time. The defendant, the cause of her death is complications of blunt force head injuries. The autopsy revealed not only that subdural hematoma that was viewed at the Children's Hospital of Brockton Hospital, but also a separate subarachnoid hematoma. Your Honor, additionally, the child had an optic nerve hemorrhage that was observed in autopsy, and retinal hemorrhaging as well in her eyes. Doctors that treated the child at Children's Hospital have testified before the grand jury, and the ophthalmologist who observed these injuries to her eyes indicated that the type of force necessary to cause those injuries is akin to the type of force in a car accident. The experts, the neurologist as well, who treated Lyric that day at Children's Hospital, viewed the videos that Mom claimed purported to show her banging her head and causing the injury, and they have unquestionably said that that is not the possible cause of the child's injuries, that it would take significantly more force for the child to have those type of injuries. Mom's description also does not account for, as I indicated, the various bruises and cuts and scrapes in various stages of healing that were present, as well as missing pieces of hair from the child's head. The child's prior pediatrician, whose practice had seen the child only 2 months before her death, and probably just weeks before she went into Mom's custody, indicates that she could not recognize the child in the videos, not only based on the child's behavior and demeanor being displayed in the videos, but also her presentation and appearance. She said that the child previously was a very healthy 2-year-old little girl, and in this video she almost looked malnourished, like she had lost a significant amount of weight since they had just seen her in late October of 2019. Your Honor, in May of this year, we also learned that the defendant's then 4-year-old, now 5-year-old son, who was obviously placed into therapy, given all of this in his foster placement, made a comment to one of his therapists, and those records were obtained through the grand jury. The therapist was talking with the 5-year-old about safe and unsafe behaviors, and the child said to the therapist that it was unsafe when Mom hurted Lyric, and that's the quote from the 5-year-old. So there may be, while I can't tell the court exactly the trauma that caused the injury to Lyric, I can tell the court that it is completely inconsistent with Mom's explanation of what happened, and I can tell the court that obviously under the manslaughter indictment, there is a theory about an omission or a failure to act that leads to someone's death, and so at the very least, the Commonwealth, I suggest, is very strong case for that, under that failure to act. And based on, the information that we have, it also seems, potentially likely that mom also may have been involved in the actual injury, that caused her to die. Looking at the defendant's board of probation record and in support of our significant bail request, Your Honor, I will point out that the defendant has a history of violent convictions. She has 12 prior restraining orders against her. I counted 6 defaults or warrants that have entered in the past, either for failure to appear or failure to comply with court orders. She has a couple violations of probation as well. There's also a couple of specific facts that were brought to the court's attention in the district court that I'd like Your Honor to be aware of. According to the DCF records that we obtained during the course of the investigation, previously, in 2017, when DCF was attempting to get custody of the defendant's children, she threatened that she was going to be on a bus to Alabama and nobody would ever see her or the kids again. And I have those documents if you'd like to review them. They were marked as an exhibit in the district court, so I know Mr. Tomkowski has them as well. We know that she has family in Mississippi as well, because on the night of this incident, she apparently called a family member in Mississippi at the time that Lyric was in this distress. We know that she has family in California as well, because since the pending case in district court, she has at one time attempted to travel to California to visit with family related to the death of a family member. However, that request never went actually fully before the court, and the Commonwealth did oppose that when I was speaking with counsel. But based on that, we know that she has ties to other states and has in fact threatened to leave before. I suggest when something much less serious than a 20-year manslaughter felony was facing her. Your Honor, one of the other things that I did present at the district court arraignment, I think is relevant and important, as I indicated, we had Ms. Leonard's cell phone, and in October of 2019, again, maybe just a week or a couple weeks before she obtained custody of Lyric, her text messages seemed to indicate that she was purchasing an illegal firearm from someone. And the text messages are a conversation between her and another individual, where she's asking about the price of it, and the individual texts her a photograph of an item that appears to be a black firearm, and then they make arrangements where they can meet up and agree upon a price for that firearm. Again, I know these are only text messages, but it's certainly, I think, relevant in the court's consideration, and it was before the district court when the determination was made. So for all of those